It was all a dream. I used to read Word Up magazine. Marquel K with K Mark Laws in a limousine. Back with another resource for y'all. Today we talk getting your money under the law. Say you win a lawsuit against another party, and the court orders that other party to pay you for your loss according to the judgment. The favorable ruling may give you an immediate sense of relief, but unfortunately, your problems aren't going to be completely over in every circumstance. In some circumstances, you will have trouble collecting this judgment after the court has ordered it. Failure to collect a judgment from a lawsuit is a common problem that a lot of my clients face. An experienced attorney knows that whenever you get a judgment in a case, there's no guarantee that you're going to be able to collect that judgment from the opposing party. Some clients or opposing parties are what's called judgment proof, which means they don't have any assets, they aren't ever really going to make the money, and they aren't ever going to have the ability to pay you the judgment that's owed. But these are three tactics that you can use to employ in a situation where someone owes you money due to a judicial judgment but refuses to pay you. The first tactic that you can employ if someone refuses to pay you according to a court order or a judgment is obtaining a lien on their real property. If the debtor doesn't comply with court order and refuses to pay you, your attorney or yourself can file a transcript of judgment to obtain a lien on that person's property so that it can be used in collection proceedings. If the debtor has property in more than one county, you want to record this transcript of judgment in every county where that person holds property. The judgment lien is going to attach all of the judgment's debt to the real estate located in the county or counties where the transcript is filed. After you and your attorney get a judgment lien against the debtor's real property, you can seek a writ of execution and file a certificate of levy to execute on the property. Your attorney can check with the county assessor's office and determine whether the debtor owns property if you're unsure if they own property, but many counties provide this information free for the public on their websites. Obtaining a lien on real property allows for the sale of that property in certain circumstances, and the proceeds that are gained from the sale of that property will go towards satisfying the debt or the judgment that they owe you. The second tactic that you can employ in a situation where a debtor refuses to pay you a judgment ordered by a court is collecting from that debtor's wages. You can obtain a writ of continuing garnishment to garnish the debtor's wages until you're paid the judgment you're owed. As the name states, a writ of continuing garnishment is a way for you to continually garnish their paychecks to collect your judgment and payments over time. A writ of garnishment in most places will be good for up to 6 months. In Colorado, for example, this is the case. And if the amount owed to you is not paid off by that time, or unlikely to be paid off, you can serve another garnishment. The third tactic is very similar to the second, but you may want to get an attorney for either one of these options because they're both procedurally intensive, which means they require a lot of legal paperwork that often requires an attorney to help you with or to fill out or to walk you through to complete the process. It's wise to retain an attorney in these instances because you may skip a step or miss something or not provide something for the court, and then you went through the process for no reason. You've paid filing fees for no reason. You've served the other party and paid those fees for no reason. But the third option or tactic that you can use is to garnish or collect from the debtor's bank account. Rather than collecting from their wages, you and your attorney can levy the debtor's bank account by asking the court to issue a writ of garnishment. There are several forms that must be completed in order to complete the writ of garnishment, and it's very tough to complete a writ of garnishment, but sometimes getting the judgment or the court order is only half the battle. Sometimes when a debtor is hiding assets or refusing to pay, you may need to get an attorney to delve deep into that person's assets, and you can recover the judgment directly from their bank account. That's all, folks. Thank you so much for joining us today. Keep in mind, these are only 3 tactics that you can employ if you have someone who's refusing to pay you pursuant to a court order or a judgment. And keep in mind, you'll want an attorney likely for employing any of these scenarios that we outlined today because they're very tough to complete on your own. This has been 3 tactics you can employ in the case where someone refuses to pay you a court order or judgment. We hope this was helpful. Once again, I am Marquel Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business, stay frosty, my friends. We'll see you next time.